Babu and Arvind. All my 6-7 steps apply to each of them in varying degrees. Now, I want to cite two cases of lines of law which are very important. One is, what is the weight and relevance of a co-accused statement? Your lordships as well as got everything organized in the law beforehand. People knew this was happening. Courts knew that. It's so easy to extract incrimination out of co-accused, because the co-accused is basically concerned about his own selfish ends. Therefore, very little weight must be given unless you have clear corroboration. This is a remarkable case by a single corroboration, one piece. Now let's go, one by one. Come to Surinder Kumar, which is page 12 of my compilation law. Somebody is again intruding. The court master may tell them to. Surinder Kumar Khanna is page 12. I read, Manas?
Yes.
Now, Surinder Kumar. Para 13, it is accepted that apart from the aforesaid statement to co-accused, there is no material suggesting involvement of the appellant. We are thus left with only one piece of material, and that is the confessional statements of the co-accused. On the touchstone of law laid down by this court, such a confessional statement of a co-accused cannot by itself be taken as a substantive piece of evidence against another co-accused, that is me. It can at best be used or utilized in order to lend assurance to the court. And this is a star witness. Pardons, bails, and co-accused are their star witnesses. There is no corroboration. In the absence of any substantive evidence, it would be inappropriate to base the conviction of the appellant purely on the statement of the co-accused. This is the Supreme Court saying so innumerable times. This is one example in 2018. The second case is the next one, Kurmi's case. Now, this I have deliberately chosen. It's a constitutional bench in 1964. Your lordships laid the foundation of criminal law much earlier. They are being decimated by an agency called the PMLA or the ED. The statements contained in the 1964 judgment, brothers. The statements contained in the confession of the co-accused stand on a different footing. In cases where such confessions are relied upon by the prosecution against an accused, the court cannot begin with the examination of the said statements. The stage to consider such confessional statements arise only after the other evidence is considered and found to be satisfactory. That is in trial. Today there is no other evidence. None. The difference in the approach to which the court has to adopt in dealing with these two types of evidence is thus clear, well understood, and well established, apparently not to the ED after 60 years of a 1964 judgment. Confessional statement of a co-accused can be acted upon if it is corroborated in material particulars. As we've already indicated, it has been a recognized principle of administration of criminal law in this country for over half a century. In 1964, they are talking of half a century. From 64 to now is 60 years, plus 50 years. The ED has destroyed 110-year law of line of law. It has been a recognized principle of administration that the confession of a co-accused person cannot be treated as substantive evidence. It can be pressed into service only when the court is inclined to accept other evidence. There is no other evidence, and feels the necessity of seeking from an assurance in support of its conclusion deducible from the said evidence. Lastly, on this point, Sanjay Jain, which is just above, going back to page 12, item 9, just one para. This is Delhi High Court. I already cited constitutional benches, Supreme Court, this is Delhi High Court. It is tried that the court cannot start, my learned friend, starts and ends with that, with the confession of the co-accused to arrive at a finding of guilt. But rather, after considering all other evidence placed on record and arriving at the guilt, can the court look at the statement of the co-accused to receive assurance? That's the meaning of corroboration. You have basic evidence and you then need some reinforcement. Thus, the confessional statement of a co-accused under 50 is not a substantive piece. This is section 50 case, 50 case. Not a substantial piece of evidence and can be used only for the purpose of corroboration in support of other evidence to lend assurance. Now, this creature, this species called approver, the court used some very, very, very felicitous language to describe the nature of an approval. Well, in our history, whether for good motives or for bad motives, your lordships have dealt with phrases like Jechans and Trojan horses in very different way. My lord always looks very, very harshly. History always looks very harshly at Trojan horses. Lordship remembers all the people who came in the Trojan horse. They did daga, they did betrayal, as well as Jechans in our other history books. Now, the court puts it very well in Ravinder Singh, hearkening back to that sentiment. Ravinder Singh is 1975. That
Yes,
was
sir.
almost 40 years away.
Me too, sir.
45 years ago. An approver is a most untrustworthy friend.
I don't.
If at all, the word friend is below an oxymoron. Because if you're a friend, you should not and cannot be untrustworthy. So the court says, most untrustworthy friend, if at all. And he, having bargained for his immunity, must prove his worthiness for credibility in court. Here it is worse, because the man never bargained initially. He suffered. When the water came over the head, and he got bail, and he got approval, and he got every concession from the ED, he then sang Malas. Then Malas, I've got 2 or 3 more points and I'm ending shortly, Malas. Arvind, your lordship has noted my point. Malas, there is another part of this evidence which is forgotten frequently, and your lordship will note 2 Delhi High Court judgments which remind us that it's very wrong to forget this principle. It is routinely forgotten, even by courts, Malas, and certainly by the ED. The principle is that a Section 50 statement, although admissible under the law, it should not be given very high weight because it is at the non-cross-examined stage. There's a very interesting nuance by Delhi High Court, twice. Yes, you come shouting from the rooftops 50, 50, 50. Unlike 161, it is admissible, it can be relied upon. Okay. But relied upon admissibility is one fact. Weight, importance, and relevance and dispositive value given to it is another. Both the courts say you are at the beginning of pre-trial. You are at the intermediate stage. When that statement has suffered the glare of cross-examination, it acquires a higher weight. Its weight today is very low. My learned friend is only relying on that low weight. Well, there are 2 cases, Khandelwal and Vijay Agarwal. Khandelwal is serial number 12. Or should I go in sequence?
13.
Take a Vijay Agarwal. Take a Vijay Agarwal first, and then 13 is Khandelwal, one after the other. Item 12 and 13. Vijay Agarwal is the Delhi High Court last year. In the present case, the petitioner is stated to be a renowned developer, and his plea that he did not know that he is dealing with the tainted money cannot be brushed aside mechanically. I hope I'm clear, Melissa.
Yes, sir.
If the liberty of an individual is concerned, the court cannot proceed merely on the basis of assumptions and presumptions. Now read the underlined lines. The evidentiary value of the statement recorded under 50 of the PMLA has to be tested at the end of the trial, not at the stage of bail. I'm on a much more fundamental, even if for sure I am on the arrest validity itself. Forget bail. I'm even prior to bail. The twin conditions of 45 do not put an absolute restraint on the grant of bail or require a positive finding qua guilt. Khandelwal, next item. So well as the probative value of this 50 statement is much lower near the vanishing point 0 small low versus the higher level after the trial starts and the cross-examination is done on the same 50 statement. On the same 50 statement. Chandraprakash Khandelwal. What weighs the statements under 50 would carry, well, this, the typo there, it should be what weight, not weigh. T is missing. What weight the statements under 50 of the PMLO carry at the end of trial cannot be tested at the stage of bail. That's all that I want to say. That's the only 2 lines are sufficient. I now turn to Malaz, the point which is already decided in Manish Sisodia in my favor, yet the ED persists on the same point against Kejriwal. That's my 9th point, fellas. The last was the 8th point. Now, what is his 9th point? The whole case is, I've read page 378. We want Kejriwal to find out more about the proceeds of crime, to find out about the flow of the proceeds of crime. I hope I'm clear. Now, the proceeds of crime flow is quantified by the ED to be 45 crores for this purpose, for this argument. The same 45 crores for the same accusation in the same so-called liquor scam was dealt with both legally in law and factually and rejected by Manish Sisodia, para 15, which I now request your lordship to turn. That is one case not in my compilation. It is emailed, Manish Sisodia, Supreme Court, and Mr. Shadan kindly make sure of it. Mr. Vivek Jain kindly make sure of it. Para 15 of that. And to Mr. Raju, of course. It's a judgment of my Lord Justice Sanjeev Khanna called Manish Sisodia. It's a single email, para 15, page 24.
Sir, the email has to go. Email has not gone. So I think it's gone now.
To the learned judge,
Yes.
Mr.
To
Raju,
So, Singh, are you reading the unreported version or reported version?
reported.
Unreported.
Okay, we have it. We have it.
Mr. Raju and the learned judge.
I have it.
Okay.
It's mailed to the learned court master.
So both Mr. Raju and Mr. Zoev have it. My lords may have it, perhaps.
It's been mailed to the learned court master.
Just open fingers. You can actually fill your mail finger.
Mail sent.
It will take 1 minute.
Yes, but certainly this is very important. Let the mail be traced.
That is 2 minutes. Yes.
My lord has got it.
People, maybe sign that. One second, please. Maybe one. Alright, so I have it now.
My lord has got it.
Yes.
Just come to page 24 with the unreported copy. Para 15 is a better way of looking at it. Both the law and the facts. They first cite the law and then they apply it to the facts. Keep in mind, it's the same liquor scam, it's the same proceeds of crime. There is no difference. Amount is the same, quantification is the same. The names of accused being different makes no difference. May I read, Manas?
Yes, I have it. Yes. If you want to read, please.
I'm sorry, Manas, I can't hear your lordship. May I read?
I have read it, otherwise I have read it.
Oh, I see. I'm sorry. Yeah, but allow me 2 minutes. Just if your lordship doesn't mind. Come to the 7th line after the beginning.
Yes.
Exactly the same argument was made. There's a proceed of crime, he is involved, etc. The power and dominion over the substance is therefore fundamental. The stand of the DOE as to the constructive possession will be satisfied only if the dominion and control criteria is satisfied. If the proceeds of crime are in dominion and control of a third person and not in the dominion and control of the person charged, that is me, the accused is not in possession of the proceeds of crime. So unless your lordship finds that the dominion and control is mine, and there is not a word, it would be different matter when an accused, though not in possession, is charged for use, concealment, or acquisition, or projects or claims. Not a word about any of the 6 ingredients of section 3. Not a word. How, when, why, which manner, what. See the last sentence. Prima facie, there is lack of clarity as specific allegation on the involvement of the appellant, Sisodia, direct or indirect, in the transfer of 45 crores to AAP is missing. Now, Maharaj, it's the same party, the same everything, and there is nothing apart from using the section's words. showing use, projection, possession, blah, 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 etc. under section 3. I now come to Malus, and the Lordship will just write on the side with respect to page 378 of what I read to your Lordships from the grounds of arrest. Now, Malus, kindly come to my last 2 points. The penultimate point is vicarious liability. Now, Malus, vicarious liability law remains the same. It is not that vicarious liability is a part of general law and vicarious liability is abolished as far as PMLA is concerned. I hope that stage is not reached yet, Malus. Nobody here argued it. And I don't think Malus vicarious liability can be fastened on a more draconian provision. Now, here is a case of complete vicarious liability. Let me explain why very quickly. First, section 70 is the only section applied. Not by me, by you, Mr. Didi. Number 2, section 70 on the language your Lordship has the PMLA specifically applies to companies. 3, whatever the language of 70, it does not specifically, conversely, it does not specifically address political parties. Or political parties are specifically addressed in a different statute called ROPA, Representation of People's Act, 2F, 2 bracket F. Don't go to it. Lordship will take my word for it. ROPA. Sub-point number 5. You cannot therefore subsume a definition of a political party already given in ROPA by your say-so in another section of another statute, PMLA section 70, without the PMLA naming a political party. You are actually doing violence to 2 acts. You are ignoring 2F and you are inserting political party under 70 artificially. The last and the most important, when you bring up a political party, assuming you can bring up a political party, I'm objecting to the bringing of a political party. I'm saying it is not the correct, it's an ultra vires application of 70. In the alternative, if you bring a political party, it doesn't automatically make Kejriwal guilty or liable to be arrested. In addition to bringing in political party wrongly, you have to show the role of Kejriwal, how, what, when, where, in terms of the 6 tests of section 3. Otherwise, it becomes a complete vicarious liability. Not in terms of predicate offense. What is now frequently happening, unfortunately, is that the ED is the super investigator of the predicate offense, forgetting its own domain, creating use, projection, conversion, blah, blah, all those section 3 points. Now here, Malaz, if you apply 70 in a vanilla formulation, forgetting the first part of my argument that you cannot apply 70, there is no political party, etc., etc. Investigate the commission of the offense, which CBI is investigating. You don't tell the court how under ED section 3, this man's role. So clearly, Malaz, the person is being charged vicariously. That is my penultimate point, Malaz. Malaz. Being illegal. The answer to that can be arrest is legal, arrest is illegal. In either event, the interim and the final prayer as drafted and put is identical. In either event, the entire case depends on only two things: what the ED has already spoken. ED can and has already spoken in the most detailed grounds of arrest. I am quite amused, Malas, when I argued Pankaj Bansal till one day prior to the judgment. ED's grounds of arrest used to be less than half a page. It is, of course, some gain we have got on a permanent basis that ED's grounds of arrest are now, Malas, many, many pages. It started 2 days after Pankaj Bansal. Now, Malas, ED is frozen in time in giving you Lordship's grounds of arrest. It is frozen. It is neither for him or for me or the judge to add, subtract, modify, do anything to those grounds of arrest. They cannot be. It is not Mohinder Singh Gill, Malas, the civil law. It is much beyond Mohinder Singh Gill. This is criminal law. The grounds of arrest are frozen. Equally, Malas, that freeze has been superimposed and interpreted by the order of remand. I ask myself the question that apart from a motivated malafide attempt to delay proceedings, what is this, Malas, when prayer is identical, grounds of arrest are known, everything is to be argued, Lordship is to dismiss it or allow it. I cannot object to either result, that's your Lordship's domain. Neither can my learned friend object to either result, it's your Lordship's domain. Therefore, Malas, I beseech my lords, this is a matter where, Malas, democracy is, and I hate to use rhetoric, I've been as specific on the law as possible. It is not rhetoric, it is the reality. It's reality, not rhetoric. Democracy itself is involved, basic structure is involved, level playing field is involved. A few hours is too long if the arrest is illegal. A day is far too long if the arrest is illegal. A week is unthinkable if the arrest is illegal. You are actually, Mr. ED, inch by inch achieving your object, a nefarious object of rendering most of the petition infructuous by seeking such time. You should live or die by your merits, and you should, Malas, kindly consider, I beseech my lords to consider a, Malas, allowing of the relief of release or deciding the matter either way and not allowing any delaying tactics to take place. I'm extremely grateful, Malas, for a very patient hearing despite very, very, very many interruptions, both technology and otherwise.
You're welcome, sir.
May I?
Yes, you can now submit. I object to other, there can't be more than one lawyer for each person.
Mr.
I
Raju,
object to others
we have just divided some of the issues.
No, it can't be divided in
Dr.
it's
Singhvi
unheard
and
of.
myself.
It's only,
Raju,
no,
we
it
have
can't
just
be
divided
divided.
some of the
My
issues and
never
give us
said
a
that
few
in the
minutes.
beginning.
We are
It can't be done. It's never done, Mr. Amit Desai. It's never done.
We are
Either
not
one lawyer,
repeating.
You can't have three. Otherwise, I went for ED. I'll have 10 lawyers appearing. That's not fair. I'll have 10 lawyers appearing for ED. This
Raju,
can't be done.
Raju, we have divided
I
the
want to,
issues.
then your leadership, if more than one is lawyer, the ED will argue with 10 lawyers.
So we have just got a few more minutes to supplement. We are not going to repeat.
No, a few
what
minutes.
Dr.
It's
Singhvi,
not a question.
I'm
It's
not going
not
to
a
repeat
question of few more minutes.
what
Amit.
Dr. Singhvi has already
Mr.
canvassed.
Desai, it's a question of propriety, and it's a question that for one petitioner only one lawyer is allowed.
I think with the
Just
discretion of the
this
court,
principle
we
is
have
going to
divided
go by because of the stature of your the petitioner. Then even ED requests that 5 people may be heard on behalf of ED.
Give me a few minutes.
enough.
Probably
Let it be a level playing field, sir. You want a level playing field. I'm asking for a level playing field. If 3 lawyers appear for you, 3 lawyers will appear for ED. Give us the level playing field.
If I may just give me a few minutes.
So, but I think Mr. Raju does have a point.
Yeah, we've just, all that I said is that between Dr. Singhvi and me, we divided few of the issues. Dr. Singhvi has covered larger issues, the constitutional issues. There are a few factual issues that need to be touched upon and dealt with, and that is the end of it. And some issues of pure criminal law, which need to be touched upon and dealt with. So that's all that I'm going to be wanting to supplement Ms. Dr. Singhvi's submissions.
Also wants 2 lawyers, 2 senior counsels.
I'm sorry?
You see, then ED will also have some more counsels.
ED will require 3. Mr.
Raju is enough for all 10 of us. He
Vikram
doesn't
Chaudhary is waiting in the wings. Mr. Vikram Chaudhary is waiting in the wings. He'll be the 3rd person to address.
I began with this. Let us be fair to all, and I will finish with it only. Let us fair be to all. So if one council, senior council is to appear for one person, then he has to. Otherwise, for ED also, I will have the same.
I'll ask 3% to appear for ET.
Mr. Raju, आप गुस्से में क्यों?
I'm sorry. Because they're accusing me of they are delaying.
Mr. Raju आज बहुत गुस्से में है. Normally
competent
Mr.
enough
Raju
to
is not
argue
doing
for all
this.
three of them.
Now, everything a judge says, it is given some of the color. Please let's be clear here. This was just in light of it. What I'm just saying is, I said that in the beginning that for the main petition, I am here. I am issuing notice to them. We want an order.
Yeah.
I will pass an order on that. Mr. Singhvi said when he began that he has to only tell me briefly.
That's right.
Since each day in incarceration is unconstitutional, and I should pass an order on that. So I have limited myself to this. I heard Dr. Singhvi. He has told me not only constitutional provisions, he's also touched upon the criminal. Now I wish to hear Mr. Raju, because I have a whole other list also pending, which I have to hear. So I think that we can move on to Mr. Raju. Otherwise, you see,
I'm in the hands of the court, but we are only going to supplement. And Mr. Raju today is in a very different mood, so I don't know what to say.
Dr.
Repeat.
Singhvi is competent, capable, and he's done it.
Of course, there's no doubt about that, isn't it? And you will handle all of us, Mr. Raju. That also we know.
document, but then you see, this is an issue that one person can have one senior counsel.
Yeah.
One person can have one senior.
So if your lordship will permit, guys, we are
Whatever you have to say.
Correct.
All right. So you can just email it to me, and I will make it part of my order. Will that be all right?
very well. Then we'll just see. If there's a need, otherwise I'll cover some of it in the rejoinder. That's all right. We'll
Okay.
see where it goes. We'll see where it goes.
Right. So that's all right. So in rebuttal, he can for 5
Yeah,
minutes.
that's right.
Many
Yes.
times it happens that such a important matter, people pray to the garage. Though my learned friend is not of that type, but sometimes it happens. So somewhere the break has to be put.
Yeah.
Now
Here only on constitution and law, Mr. Raju. I think you should know me by now.
we are now. My first submission is that I require time to file a reply. Elaborate arguments have been made for more than 2 hours.
लिखो.
And then to say that no, everything you argued, it's there, everything is there. There's nothing for you to argue. Then it may as well be that without hearing me, the order this, but that's not the law. Even where the question was almost covered, the Supreme Court has taken the view that the party is entitled to be heard. Kindly have a look at 1993 supplementary 1 SCC page 405. I think I've sent it. It's not there in my compilation.
It has been emailed to the court, Master Mullah. It has been emailed to the court.
Mr. Raju has already said I am issuing notice in the main petition. I am issuing notice. I have already said it. I am issuing notice, and you will get time to file a reply. So
I
they,
need time to file a reply both to the main matter. Issuing of a notice is a prerogative of the court. I can't object to issuing of a notice. And I'm not objecting to it. But interim relief, yes, interim relief, I have to be heard. I have to be given a right to reply. And I should be given an opportunity to point out the flaws in the arguments and the misstatements, if any, made as far as facts are concerned. Otherwise, everything is accepted. Then where is the need of hearing me? If I'm not not entitled to give a reply, then don't hear me. It's as good as refusing hearing to me. Giving of a reply is part of hearing. The right to be heard includes the right to give a reply. I can't be deprived of that right merely because it is filed at the last minute. I'll tell what has been done. Those 2 objections which were there were absolutely small objections. It was a deliberate delay on their part to see that the copy is given to me at the last minute so that they can take an objection that, look here, we filed it 3 days back, but the objections were there. We had removed it on the last date. Therefore, we could not give a copy. But look at the type of objections. Absolutely, almost, if I can use the word absolute useless, I'll point out what the objections were. But first have a look at this judgment. 1993 Supplementary 1 SCC, page 405, 3 judges of the Honorable Supreme Court. Now look at the objection. Despite this, the Supreme Court says entitled to be heard. Kindly have a look at paragraph 4. Your Ladyship is having the judgment.
Was sent via email at 11:18 a.m.
Please send a copy to us also, Mr. Gurnani.
Sent it to the colleagues in court.
We have received it. But...
The contention there was your Ladyship has got the judgment.
No, not yet. Which one is this? Which one is this? Can someone tell me?
Was the email-
Union of India versus
email
Mohammed Ahmed Ibrahim, 1993, Supplementary Volume 1, SCC 405.
First आपने मुझे दी थी ना
Email which was sent at 11:18 a.m.
what 11
Send another
11:18.
copy. Send another copy just now.
We'll send one right away.
no.
डालो फोटो
पेज नंबर है
Yes, Mohammed Ahmed Ibrahim.
Yes.
Right.
Kindly have a look at para 4.
no
The contention was that the documents supplied to the detainee were illegible and unreadable. That was the only issue. Then in that context, kindly have a look at the paragraph which starts at placentum, subparagraph which starts at placentum E of para 4. It would appear that the returning authority sought extension of time to file its reply. My Ladyship has got it?
Yes.
It would appear that the detaining authority sought extension of time to file its reply to contest this averment as to the alleged illegibility of documents. According to the appellant, they desire to indicate that documents served by them on the detainee were not illegible, but it did convey effectively the purpose, purport of their content and the purpose relied upon. The High Court was of the view that there was no justification for any such opportunity, as according to High Court, no issue was served by adjourning the petition for filing a reply, because the point raised is such that it does not call for any reply. Therefore, the High Court said no need to file a reply. Same contention of Mr. Singhvi, that no need to file a reply. You argued this point before the.
I have in my mind to that. I am issuing notice in this, and I'm giving you time to file a reply. I've already said that. Now,
Very
I
good.
just wanted to know, as far as they said that there is an interim that they are seeking for that.
I'm addressing on interim, therefore reply even for the interim. I require a time for filing a reply even to the interim. Now kindly have a look. Therefore, para 7, the High Court says the Supreme Court says the High Court is wrong in not granting time. Now come to para 3 of their interim application. Interim is based on the final. Kindly have a look at para 3 of their interim application.
Mr. Hussain, can you hear me?
Yes, my lord is audible, but a lot of chatter in between, my lord.
I can't, because even practice for me also. I can't tell people again. I told you once.
I
Now,
can request the court master, my lord, to mute everyone else.
so what I'm saying is, ask you before deciding that. When did you receive this? When did you receive this petition? The entire
Yesterday.
Yesterday, my lord.
yesterday in the evening?
Yesterday at
Afternoon.
afternoon, my lord.
Yes.
Before 12 p.m. Laws has been served before 12 p.m. yesterday on them.
No, I that I also received the file.
अगर मैं तो गूगल पे डालूंगा तो ये तो मैं तो चैट जीपीटी प्रॉपर
There is a lot of people speaking, my lord, on the
Change the date.
Shivendra is
मेरा face का
I'm Shivendra.
Is on mute, please.
तो हस्पताल का स्कोर वापस
सर प्लीज बाकी लोग अपना अनम्यूट कर लीजिए,
म्यूट कर लीजिए।
म्यूट कर लीजिए सर प्लीज।
Now kindly have a look at page 397 of his interim application. Para 1. Petitioner sanguine in the success of the main petition. Therefore, brevitas causa, contents of the main petition may kindly be read as part and parcel of the instant application. So they want the main petition to be read as part and parcel of the interim application. If the interim application is being adjourned and time is given to file a reply, this application can't be heard because the basis of this application is the main application, as per their own admitted averments.
No, that is a standard government in any IAM.
Maybe a standard or not.
That's a basis
Sorry,
for taking
I
time.
never interrupted. I never interrupted, sir.
Standard, then should I presume that you don't want me to read the petition as part of it? So then I will presume that because when you were arguing, you were reading from the main petition too. So if you want me to refer to that, if you want, then this is not a standard paragraph, right? You want me to read that also because you have argued at length. So I think in these circumstances, when they have got it in the yesterday afternoon, then I am issuing notice to them. So in that case, please issue notice returnable on. Please tell me a date.
May I just make one submission? If Lordship will permit me, just one submission on that. Plus, we moved on Saturday. We moved on Saturday. We sought an immediate hearing from the High Court. We sought to mention before the Honorable the Acting Chief Justice. We were informed by the registry in the evening that the matter will be taken up on today as the first item on account of the urgency. Plus, thereafter, the registry was closed. And the minute the objections were marked, we cleared those objections and we reserved on the party. Plus, it's no account to the petitioner that there has been a delay in this matter, not even a moment. We have been anxious of the hearing from the day one.
To know how malafides are there and what they have done. I just point out so that it is deliberately.
We have served them. We have enough time, like it's already submitted. This is only on the procedural aspect, so I'm submitting, but Dr. Singhvi has already submitted. These are matters of record. A delay very strongly prejudices us. We have not sought a single delay in this matter.
Out the delay of
the holy vacation.
How they have done.
Can I say something? The objections are cleared at 11:30.
Look at the nature of objections. And we have been writing to them, let us give us a copy, give us a copy. They did not give us a copy.
At 11:30.
Let me make my point, Ms. Dr. Singhvi. I never interrupted you. Let me make my point.
Yes,
now the objections which were there, they filed the petition on Saturday. Fair enough. We asked for a copy by writing emails to them. Emails have been sent to your ladyship. We wrote them emails on Sunday, Monday. We wrote two emails to them on Sunday and Monday. They did asking for a copy. They deliberately did not reply and give us a copy on 24th and 25th. Those two emails we have forwarded to your ladyship. We asked for a copy. Now, what are the objections? What are the defects? Defect number 1. Description of any other defects. Typed copy of annexure P12 and 13 be filed. Annexure P32 is incomplete. Service to respondent, service proof be attached. That is the only objection. They could have given
notified
us
11:30 to us.
Nothing prevented them from giving us copies subject to the objection. They will give you the annexure P12 and 32, which you already have.
Can I cut through
They
this?
did not. Why? They did not want us to be prepared and argue this matter. They deliberately did not give us the copies. They're talking of level field. Where is the level field when you have different yardsticks, different standards? That is what we are going to show. But you don't allow us to show, you don't allow us to do justice by deliberately not giving us copies, despite our emails asking you for those copies. You file it and say, no, there's a defect. What type of defect? It's as good as a useless defect. That type copy not given. You could have sent it. You could have given us copies.
How do we know what defects will be marked? Registry which marks. How do we know what defects will be marked? This is extraordinary submission. Plus, how will we know what defects will be marked?
Because
Well,
it is extra. It
the
may
practice
sound
in this
extraordinary.
court is
In
that
the
a
facts of this
cleared copy
case,
is
when we want
submitted.
an
That's
early
the practice
hearing,
in this
it was
court.
your duty to give a copy to us. In the
Well,
facts
this
of
is
this case,
extraordinary
because you're asking
submission,
for
Viraj.
early
The
hearing,
practice in this court is that a service is
where is
done
the
where
practice?
objections are
You
cleared.
would always go by
Rules
the
cannot be
practice.
changed
I'll
to the
point out
ED.
what the practice and how you have flouted the practice.
He's
Don't show me the
telling the other
practice.
side is to keep quiet. Let him finish. When I'm giving you a patient hearing, then please have this decorum.
When it comes to practice, there is a double standard. For them, the practice is different. For us, the practice is different. So for
Lord, I'm not
those
sure
documents, they
who
could have
is
given,
Mr.
if they wanted actually hearing today and a genuine fair hearing, wherein we could have come prepared, they would have served us a copy on Saturday itself. And they did not serve it. We sent a mail on Sunday, no response, no copy served. Monday we sent another mail, no copy, no response. And on the pretext that this defect you could have removed on Saturday itself. This is the absolutely
You send those emails.
defect.
The rice
Now when
field
I
was
asked
not
for time, you said,
functioning
no,
on
it should have been
Saturday, so
ready.
how could we have?
Therefore, you are responsible for delay.
You
We have
have
sent those emails to your ladyships.
If
We
you're
have
so,
sent those.
if you're so,
you, Mr. Raju. I
Can we move ahead? Can we
understood
move ahead, fellas?
them also. I think I understood them also. I understood you also. So let me pass an order. I will pass an order. You may find out the order at 4 o'clock as to what I am doing with this.
But as one sentence before Your Lordship reserves the matter, my request is, liberty being what it is and the context of this case, Your Lordship may give them time till the end of the day today or call it tomorrow. Or call it
you
tomorrow.
can't dictate the time. You
Well,
can't
I'm
dictate the
making a
time.
request, sir. There's no dictation. You are the
It
one
takes
who's
3 days to
dictating.
remove a defect.
No, I have not heard the other side, so there's no question of reserving the order. Since I will be hearing them and then I will be
No,
giving.
I'm saying on the time, Your Lordship may give them time till tomorrow, given the extreme urgency is my request to Your Lordships. Rest I leave to Your Lordships. I can't ask more than that.
Right.
I am saying,
Therefore-
my request is that, well, this is a matter of great moment and urgency. Your Lordship, I was going to ask for today itself.
Okay.
But if not today, then tomorrow.
Okay.
Please have it today in the
Can't
late
declare
afternoon
today.
or have it tomorrow.
I would
That's my
require
request.
minimum 2 weeks, but I leave it to your ladyship.
I
You
will-
can't look at the voluminous documents that they produce.
I will
I
pass
am
an
not
order.
as capable and competent as my learned friend
Your
Dr.
Lordship
Singh,
should
but
decide it
what time?
otherwise
I'm not
and deal
sure.
with it and give a final order which fellows can be dealt with either way. But this is my request to Your Lordship.
Order at 4 o'clock. We will pass an
May-
order.
Lord, may only note,
Obliged.
Lord, may only note one thing. Prayer C in the main relief is identical to the interim relief. My Lord may note that. And second thing, my Lord may
I
note
forgot
is
that point. I forgot that point. If the interim relief is granted, it will tantamount to allowing the main petition. Therefore, I require more time to prepare.
Yes.
And therefore, as far as the main petition is concerned, then it will become almost redundant, the hearing, or have OTOs.
Right. Okay. I understood. I
and
understood.
my Lord, the grounds go all the way up to triple B. ZZ, then triple B, my Lord.
4:30, 45. You can find the order. I will upload the order. Right.
Obliged. Obliged.
So rest of the matters after lunch. It's already lunchtime. Right?
Rest of the matter after lunch.
Lordship, I just mentioned item number 4 for the adjournment.
Mhm.
Lordship, at item number 4, I am seeking an adjournment, Lordship.
Hang हो गया